Welcome back for yet another stimulating and exciting session of legal environment of business. Today's topic, the law of administrative agencies. The problem that we as business people have is that not only do we have state law and perhaps federal laws to be concerned with when we are conducting our business, we also have rules and regulations that are created by administrative agencies that we must also concern ourselves with. So let's get started. In this chapter, you will be introduced to administrative law and administrative agencies. We will learn how administrative agencies are created. We'll learn what they do, the functions of agencies. We will learn what limitations they have on their power. We'll also talk about state and local administrative agencies. And we will also touch upon the global dimensions of administrative agencies. Administrative law is a statute or regulation that directly or indirectly affects an administrative agency. Procedural rules, these govern the internal processes of an administrative agency, how they are supposed to operate. A substantive rule creates, defines, or regulates the legal rights of administrative agencies and the parties they regulate. Okay. Administrative agencies are created by the legislative branch to carry out specific duties. There are independent administrative agencies and there are executive administrative agencies. Here are some of the federal administrative agencies. The FDIC, some of these you've heard of, I'm sure. The FDIC, which deals with guaranteeing your money when you put it in the bank. Another one, Homeland Security. We hear a lot about that. That's an administrative agency. FCC, Federal Communications Agency, regulates what goes out over the airwaves. And the reason that we came about to have administrative agencies is, of course, when this country was formed centuries ago, it was very small, very isolated, very rural in its dealings. So the lawmakers in this country were able to be effective and stay on top of creating laws and overseeing their execution. It wasn't that difficult. But time marches on, and like with just about anything else, time marches on, things get more complicated. We had, population expansion, westward migration, just huge explosions in any type of area you want to think of. Manufacturing, science, medicine, technology. To the point where Congress got to say to themselves, you know what, we're good, but we're not that good. We need people who are a whole lot smarter than us overseeing these various aspects of our society, daily functions. So, here come the creation of administrative agencies. These are agencies that are tasked with overseeing a specific aspect of our country's daily operation, such as the Food and Drug Administration. It is tasked with overseeing, obviously, foods and drugs that are consumed in this country. This administration is staffed with a whole lot of smart people. Doctors, scientists, pharmacists, nutritionists, dietitians, you name it. All people who are experts in the field of food and drugs. You know just a wee bit more than members of Congress about those things. Here we go. Reasons for the growth of administrative agencies. Flexibility. We need those expertise in those various areas. Prevention of overcrowding in courts. Well, courts are still crowded, but administrative agencies each have their own procedure that must be gone through and followed should there be a dispute that arises between an agency and another agency, or an agency and someone who must adhere to the rules created by that agency when doing business. Okay, this is where it gets a little screwy. How are administrative agencies created? They are created by what is known as enabling legislation. This is done by the legislative branch. They create agencies, administrative agencies. They grant power to an administrative agency to issue their own rules, investigate violations of those rules, and settle disputes involving those rules. Each agency actually has its own contained legislative, executive, and judicial system. Agencies have the power to issue rules that have the force of law and must be adhered to by individuals and businesses. They're not laws because they don't go through the regular process of being introduced as a bill and then sent to a subcommittee and blah, 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 blah. No, they are rules and regulations created by the administrative agency itself. But, as I said earlier, even though they're not called a statute, they're called a rule or a regulation, depending on what state you're in. They have the same full force and effect as a law. Each agency has its own executive power. They may investigate whether rules enacted by the agency have been properly followed. They have their own judicial power. They hold their own hearings and settle disputes that arise concerning their rules and those required to follow those rules. What do agencies do? They make rules. They establish standards and procedures that must be followed in rulemaking and adjudicative functions. If you drank a glass of orange juice this morning for breakfast, you kind of dealt with the Food and Drug Administration, because it's the Food and Drug Administration that says what has to be in that carton in order for that carton to be labeled orange juice. So we all are exposed to administrative agencies throughout our daily living. You on any medication, prescriptions? These are regulated by the FDA. Okay. Disputes are typically settled within the confines of the agency with administrative law judges and agency staff. The activities, routine activities of an administrative agency, they do informal advising to businesses or people who must deal with their rules and regulations. Business owner can call up the agency and say, I'm thinking about doing this. Can you give me an opinion as to whether you think I would be in violation of any of your agency's regulations if I do this? And the agency can issue an opinion. Problem is, that's all it is an opinion. They could end up being wrong when the day is over, but that's the best you have to go on at the time. They prepare reports on various aspects of what they oversee, and they issue guidelines that those who must answer to them have to follow. Okay? Rulemaking models. Formal rulemaking, informal rulemaking, hybrid rulemaking, and exempted rulemaking. Informal rulemaking. An agency drafts rules in consultation now with interested parties. I mean, the FDA, when they're thinking about making a new rule concerning some type of food, they're going to probably talk to people who make that food for a living. I mentioned orange juice a few minutes ago. They want to make a new rule relevant to what constitutes orange juice. They're going to want to talk to farmers that grow oranges. They're going to want to talk to manufacturing companies that make the juice. And then they will propose a rule, not create a rule at this point in the process. They will propose a rule, and it is published in a daily federal publication called the Federal Register. And it is up to people who have to deal with administrative agencies to keep track of what's going on via the Federal Register in order to make sure that they remain in compliance with all pertinent administrative regulations for them. Interested parties can file written comments on the proposed rule. The final draft is published with a statement of purpose and cost-benefit analysis. Agency receives feedback on the final proposed rule and decides if it's going to become an actual rule, if it needs to be rewritten, or scrapped, depending on the feedback they receive from interested parties. Judicial review of lawmaking. Well, administrative regulations can be subject to constitutional challenge. If the congressional delegation of legislative authority in the Enabling Act, that's the piece of legislation that created the agency and gave it its power. If that legislation was too vague and not limited, or if the agency action violated a constitutional standard, the administrative agency cannot violate a constitutional right. Or if the act of an agency was beyond the scope of power granted to it by Congress through its enabling legislation. Agencies can't get too big for their britches, so to speak. They have to operate within the confines of their enabling legislation. Their enabling legislation spells out exactly what they have the power to do, as well as what they don't have the power to do. Here's a little mock-up of a tiny, teeny little administrative agency known as the Federal Trade Commission. Oh my gosh. Yeah. Overseas commerce in this country. Right? See how big it is. Oh my heavens. Okay. Adjudication and judicial review of agency decision making. This is when somebody who falls under the auspices of an administrative agency has a problem, has a dispute. This is what happens. Step 1, notification of parties of the alleged violation. Oh boy, you're not in compliance, Mr. Orange Juice manufacturer. Negotiations with staff to effect a voluntary compliance or consent order. Let's try and work this out before it gets too involved and too nasty. Step 3, if step 2 is not successful, then the staff or agency will issue a formal complaint. Well, Mr. Orange Juice manufacturer, you're doing something that's not in compliance with our regulations, and you and I talked about it and couldn't work it out, so we're now issuing a formal complaint. Then there is a hearing before an administrative law judge, and recommended or initial decision made by that judge is sent to the full commission or to a single administrator of an agency. It's up to the administrative law judge to decide if Mr. Orange Juice manufacturer is in fact in violation of a regulation or not. The commission then, the agency then decides, makes their decision. If the loser isn't happy, you cross out of the administrative agency and you go to the United States Federal Court of Appeals for the circuit in which you reside, and you go through the regular traditional court process. However, most of these violations or disputes or discrepancies are settled at the administrative level. It's more timely, more cost efficient, and just plain old more beneficial to everyone involved to do that. Okay. So there you go. There's an investigation and a complaint. Formal complaint and hearing. The initial or recommended decision goes on to the full commission. The investigation and complaint. Agencies have an obligation to investigate when a complaint is received from other government agencies. Hopefully we can get some voluntary compliance here. A consent order, agreement by a business to stop an activity that an administrative agency alleges to be unlawful and to accept the remedy the agency imposes. Well, Mr. Orange Juice manufacturer, here's what we can do. We can issue you a consent order. And this is what you need to do to fix the problem in order to be in compliance. Mr. Orange Juice manufacturer says, okay. Because if I go ahead and fold at this point in the process, I don't have to admit guilt. Admitting guilt does not look good for me. It damages my reputation. It's better off for me to agree to a consent order for my business. A formal complaint and hearing is filed if the issue is not resolved through voluntary compliance or a consent order. Charges are assessed by the administrative law judge. They are also known as ALJs for short. They are selected on the basis of a merit exam they take and are assigned to a specific administrative agency. Many administrative law judges are retired court judges who, because of their experience on the bench or experience in practice, have a particular level of knowledge or expertise in a certain area, like pharmaceuticals. And so they will hear cases for that particular agency. The judge makes an initial decision. Final agency action, unless an appeal is taken to the full commission by either the staff or the respondent. The recommended decision is not final, requires action from the full commission or the head of the agency. Okay? The initial decision is the final decision unless someone appeals. If someone appeals, then there is a recommended decision. Okay, appealing to the full commission itself occurs in instances where the agency does not agree with the decision made by the judge. So you go in front of the whole commission. The burden of proof, the standard of proof, is pretty low. It's by the preponderance of the evidence. A bare majority of 51% of the evidence is sufficient to justify a ruling. Well, Mr. Orange Juice Manufacturer, we're about 51% sure that you're in violation, so too bad. Okay, judicial review. The affected party can file a motion to appeal with the Federal Circuit Court of Appeals. And that court can review the commission's findings to ensure that the agency acted appropriately via the Constitution. It acted within the scope of its jurisdiction as outlined by its enabling statute, and that it followed proper procedure. That's what an appeal transferring over to the regular court system can do for you. Okay, administrative activities of executive and independent agencies. They advise businesses and individuals concerning what an agency considers to be legal or not legal. You can ask for an opinion before you go ahead and do whatever it is you want to do concerning your business. They conduct studies of industries and markets, see what the trends are. They provide general information to the general public. They license businesses in areas like radio and TV stations. And they can manage property. Here are some federal statutes limiting their administrative agency's authority. All meetings and regulations must be published. Each agency must publish in the Federal Register and make sure that the public has access to that information. Agencies headed by a collegiate body to hold business meetings open to public attendance. Not a lot of closed door stuff. There is a Privacy Act, though. Agencies cannot disclose personal records without written consent. Some more, all agencies must follow uniform procedures when performing rulemaking and adjudicative functions, meaning Food and Drug Administration has to go through the same rulemaking and judicial process as the Environmental Protection Agency or the FCC. All agencies have to follow the same procedures. Okay. Tort Claims Act. This requires the federal government to waive sovereign immunity, meaning you can't sue the federal government, and assume liability for wrongdoings of an employee within the scope of their employment. Okay. Small business regulatory enforcement requires analysis that measures the cost that a proposed rule would impose on a business. That's the cost-benefit analysis that's published with the final proposed rule. Hey, you folks out there impacted by this proposed rule, this is what it would cost. This is what we figure it would cost you to make the necessary changes, requirements to your business in order to be in compliance with this rule, should it, in fact, become a final rule. Congressional review. Congress can veto power over a regulation. They have to have good reasons. Okay. Institutional limitations. The executive branch imposes limitations by the president has the power to appoint the heads of the agencies. The power of the Office of Management and Budget recommends a fiscal year budget for each agency. So, you know, the Food and Drug Administration can't just go to the Treasury and say, well, I need this much money for next year. Okay, fine, here's a check. No, they have to submit budget requests to the Office of Management and Budget and get it approved. Presidential executive orders. The President has a right to issue an executive order that could very well impact how a particular agency is doing a particular rule administration. Doesn't like it, he can prohibit it via executive order. Okay, agencies are also limited by the legislative branch because they have oversight power over agencies. They can keep an eye on them. They can investigate any potential wrongdoings. They can terminate agencies. They can advise and consent to the president on nominations for heads of these agencies. And they have the right to approve or disapprove a budget. Judicial branches can modify or reverse rule-making and adjudicative excesses. Remember, we said if an agency has enacted a rule that is in violation of some provision of the Constitution, the courts have the right to declare that rule unconstitutional and it goes away. There are also state and local administrative agencies, except in the District of Columbia, Puerto Rico, and Guam. They possess utilities commissions, zoning, real estate, supervisory boards, things of that nature. The Supremacy Clause of Article Number 6 of the U.S. Constitution plays a significant role in situations where federal and state agency laws conflict. Meaning, if a state agency issues a regulation that is in conflict with a comparable federal regulation, guess who wins? The United States government. That's who. Okay. Vonage Holdings versus Minnesota Public Utilities. The Minnesota Department of Commerce filed a complaint with the Minnesota Public Utilities Commission against Vonage, which was a phone service company, because they didn't obtain a certificate of authority for phone services. Vonage filed a complaint for an injunction. Don't let us do business while we work this out, is basically what an injunction would be. The court finds that Vonage uses telecom services and does not provide service. Federal policy encourages a conduct in state law discouraging that conduct must be preemptive. The injunction was granted to the plaintiff. Vonage uses other telecommunicative services. They don't provide telecommunicative services, so they're not in violation. United Kingdom's Financial Services Authority. This is a body that regulates banking and securities and commodities, futures and insurance in the UK. We'll be doing business there, but there is the touch upon global dimensions of administrative agencies. The main problem being the way the, let's say, insurance industry does business may be completely different than the way the insurance industry does business in Great Britain or Australia or Germany. These are things you have to be aware of if you're going to do business in those countries. The business you do in those countries must be in compliance with that country's rules. Okay, so we have covered an introduction to administrative law and agencies, how they are created, how they function, what their limitations are, and the fact that state and local administrative agencies exist, but if a state agency is in conflict with a federal regulation, federal triumphs because of the supremacy clause in the Constitution, and the fact that you have to be aware of how other countries may conduct business as opposed to how we conduct business in this country. So therein lies the administrative law for the United States. Have a great rest of your day, and we will see you in the next chapter.